what you just said is beyond the pale, that you think we can proceed to a jury trial. It's beyond an abuse of discretion. Okay, beyond. This has never before happened, I'm quite sure, I'm not an attorney, in Maryland, in the history of Maryland. You're forcing two people that has had their lawyer withdrawn to conduct a jury trial.
All right, what's going on? Levi here, and stay tuned. We have an epic legal victory to get to straight ahead. We also have some amazing court audio that you're going to want to hear. Not a second of this video you're going to want to miss out on. So guys, let's just hop right in. We're going to be actually revisiting a case that we talked about a little bit ago. We started back in January of 2024, and that is a case involving a hot air balloon company. So guys, this is such a ridiculous situation. That's the reason we're talking about it. But I want to talk about the details surrounding this case. So back in April 2021, Susan Maharaj filed this litigation against this hot air balloon company, claiming that the hot air balloon was actually invading the home's privacy, invading her family's privacy by flying this hot air balloon over top the residence. She also claimed that this hot air balloon made a extremely loud and annoying, obnoxious sound when it was being fired up. Now, if you've ever seen a hot air balloon, they blow flames up into it to try to get the balloon off of the ground. So she claims that this is torturous and a nuisance, and she is seeking injunctive relief from the Frederick County Circuit Court in order to get this hot air balloon company to stop what she alleges is invading her privacy and to stop causing an annoyance to her personal life. It's so vexatious. This whole matter was so illegitimate that it was quite frankly disgusting. So in any event, this guy, his business is called Tailwinds Over Frederick, and he does hot air balloon tours all over Frederick. You get to see the agriculture, you get to go way up in the sky, and it's like a beautiful experience for everyone. Well, in any event, he got sued by his Karen neighbor, who has more money than decency. She's married to a doctor, evidently. So she spent hundreds of thousands of dollars bringing this non-meritorious, vexatious claim against this guy and put him through 4.5 years of ridiculous litigation. We're going to actually start scrolling some of the documents on screen. This was over a 3,000-page record extract. All nonsense, vexatious claims, never actually designed to go to court, but to basically punish the defendant by way of having to drag him through a difficult experience, which in that part she succeeded at. Now, she ultimately lost the lawsuit. The breaking news is that she lost her appeal. So essentially what happened here is this woman named Susan Maharaj, who's married to a doctor, has all kinds of money, sued this guy who runs a hot air balloon business, claiming that he was breaching her privacy by flying a hot air balloon over her property. The only problem is that the airspace is controlled by the federal government, so the Frederick County Circuit Court has no jurisdiction to control what is happening in the sky. So that was basically strike one right there. But then strike two, again, this case was actually really never designed to go to court anyway, in my opinion. She had multiple attorneys. They withdrew. You get out a week before the trial was actually supposed to happen. The attorney in the case actually withdrew his appearance, and the plaintiffs in this matter actually consented to his withdrawing. So the day of the jury trial comes to court, the plaintiffs don't have an attorney, and the case basically just gets thrown out, and the plaintiffs make a big fuss about, oh, we need more time to get an attorney. Today, January 8th, was supposed to be the start of what was supposed to be a jury trial in the Circuit Court for Frederick County. Well, there was not a jury trial, and here's how today's proceedings in the Circuit Court for Frederick County went. Case called for jury trial. Plaintiffs are present pro se. Now, why are they pro se? They're pro se because only about a week ago, the plaintiff's attorney filed a motion to withdraw and to postpone the case for the third time. Now, the case would ultimately not be postponed. However, the attorney in question was allowed to withdraw from the case. So when it says plaintiffs are present pro se, that is why. it says defendants were present with counsel. Plaintiff did an in-court motion to postpone to obtain new counsel. And as you can guess, that motion in court, that verbal motion, was denied. Plaintiff then elected not to proceed with a jury trial. Imagine that. The plaintiff elected not to proceed with the long-scheduled jury trial. I'm going to keep going. Defendant requested for final judgment in the favor of the defendants. That motion, that verbal motion, was granted. Case dismissed. Judgment in favor of defendants. The plaintiffs in this case actually appealed that. They lost their appeal, and hopefully now this hot air balloon business can go back to living, a normal existence without being plagued down by a vexatious lawsuit like the one she brought against him. Guys, the reason we bring you this case and the reason we highlight this is because this shows you how bad our court system can be if you're a defendant being vexatiously sued like this guy was. Absolutely ridiculous, non-meritorious claims that were thrown out, 3 years of litigation, all to get to a jury trial, just to have this woman complain about how she doesn't have an attorney, and then she goes on to appeal it, and the appeal fails. So the bottom line, guys, is listen to this audio, check out this situation. It's totally unbelievable. You have a total Karen trying to control noise above her house and control hot air balloons, which actually are quite pleasant to look at, but claims that they are invading her privacy. The federal government controls the airspace. There's really nothing anyone could have done about this, but this is what happens when you have, like I said, more money than decency. Congratulations on the victory to the defendants. It's obviously not a surprise. But with that, guys, check out this audio of this Karen flipping out about the fact that the courts are not going to enforce her feelings.
All right, I have passed out voir dire. Does anybody have any comments on voir dire before we bring the jury in for selection?
Excuse me, I could not hear what you said.
I said you have voir dire in front of you, so it's these. You each got a copy of it. Did you have any objections or comments on voir dire before we bring the jury in and I go through the questioning?
Okay, I'm here so may I address the court?
Sure.
We need a postponement of all filings and proceedings in this case. We do not have an attorney. Our attorney has withdrawn. It is against the principles of, it's just beyond the pale to proceed to a jury trial here. That should not be necessary for me to say. We've been unconditionally prejudiced already. I can't imagine you are forcing people that do not have an attorney, that are being represented. We're not even representing ourselves pro se. We are not, we've never entered that notice for the court to say, hey, we're making our appearance pro se. Okay? We have no education, nor training, nor experience as attorneys. Even attorneys that litigate do not necessarily have the ability to put on a 5-day jury trial. So, what you just said is beyond the pale, that you think we can proceed to a jury trial. It's beyond an abuse of discretion. Okay, beyond. This has never before happened, I'm quite sure, I'm not an attorney, in Maryland, in the history of Maryland. You're forcing two people that has had their lawyer withdrawn to conduct a jury trial. There's no question that it just cannot go forward. And in fact, what we're here to do is to say that the standard 15 days that we get to retain and to search for and obtain and retain a new attorney is not enough in this case, because that's just a standard 15 days. That's if, there was a hearing, the next step was a 15-minute TWI hearing. Maybe that 15 days would be adequate. So in this case, as in what I outlined in my motion for reconsideration of what you denied, for the continuance, I requested a 45 to 60 days. I understand that was denied, but I want you to know that I didn't pull that 45 to 60 days out of the hat. I've been very diligent in trying to locate other attorneys, and that's the number that they told me that, given the complexity of this case, it's a very large case. It's been going on for quite some time. There's been so many motions, and, it's just not something that they can get into, certainly not in any reasonable amount of time, like a standard amount of time, like 15 days. So that's the number that they quoted me. Hey, I can't even entertain, being retained by you for 45 or 60 days, and then I need that time to get up to speed. So that's why I put that forward. So I don't think that's at all unreasonable given, the next step in this case, which is supposed to be a jury trial.
Okay, thank you. Dr. Blatter, did you want to add anything?
I just want to sort of reiterate, that we understand that the continuance was denied, and we're requesting, in addition to the 15 days before we'd start proceedings again, if we could have any amount of more time, to make this easier. It is a big case. It's not easy to find an attorney, but to have, any amount of time at your discretion before we start selecting juries, and, we have no idea of how to, go about doing any of that. We need an attorney.
Thank you.
Badly.
All right, defense?
Your Honor, I won't belabor the point. We've been here before. I'll rely upon what the court has twice previously ruled on that topic. As far as 15-day notice area versus Bay State property speaks directly to that point. My witnesses are here. The attorneys are here. The trial team is here. We're almost 3 years today.
Okay.
Time's up.
All right, so Judge Sandy, who is the administrative judge here, denied the continuance. It was moved to reconsider, and it was denied by the acting administrative judge, and I'm going to deny it as well, so there won't be a continuance. So your options are to go forward with the jury trial, or your case will be dismissed. It's up to you.
Okay, this is Dr. Maharaj again. We most certainly cannot go forward with a jury trial. We reserve all our rights. We do not think that there is grounds to dismiss the case. The proper thing to do, we have a notice from the court saying that we get 15 days to have another attorney enter his or her appearance. So it's, I'm shocked, Your Honor. This is beyond an abuse of discretion. This is an abuse of power over two pro se litigants. What is going on in this courtroom right now?
Well, this case has been going on for over 3 years, to my understanding. It's been continued multiple times. You consented to the withdrawal of your counsel, and you filed a continuance. The withdrawal was not contingent on the continuance. You agreed to it. The continuance was denied by the administrative judge. You moved to reconsider. It was denied by the acting administrative judge, and then you're moving for one today when the defense is here with witnesses. This case has been on the calendar for a long time. It's hard to get juries in. We have 55 jurors waiting downstairs. So, the time has come where you're either going to put on your evidence, and plenty of people do it pro se, or you're going to walk out and I'm going to enter a judgment in favor of the defense. So it's up to you. You can question witnesses. You can testify. We can pick a jury. I will help you along with it without interfering in the substantive, but I generally help pro se litigants a little bit. I'm not going to help you with the rules of evidence or things like that, but I will pick a fair and impartial jury. I've laid out voir dire that I drafted. I did not take the defenses. I did not take the plaintiffs. It's fair, it's impartial, and it will help us pick a fair and impartial jury. So you can go forward if you choose to, but if you don't, the case will be dismissed. And you can certainly preserve your right to appeal the continuance, the denial of the continuance. It's up to you.
Okay, I'd like to respond that just about everything you said is irrelevant, that the other side packed the courtroom with witnesses. We knew in December that Mr. Weddle, he made a motion to withdraw. So there was no reason.
Oh, you didn't consent? I thought I had it as a consent.
Yes, of course, it was consented. So, okay, so if we want to talk about from the time it was consented, maybe that was just January 2nd or 3rd that it was consented. So the court had noticed then when we consented. So we have an attorney withdrawing and we have the plaintiffs consenting. The other side cannot bar that transaction. So at that time, this court should have known that this trial, there was no reason to proceed with, for example, bringing in a jury. So just about everything you just said is irrelevant to what is going on here. The bottom line is two pro se litigants are being unconditionally prejudiced by being forced to proceed under these conditions. The court knew about these conditions beginning last year. Weddle is withdrawn. So now the procedure, it's remarkable. The pro se litigant has to tell the court what the procedure is. There's 15 days that the pro se litigant, from the time the attorney is accepted to be withdrawn, to have a new attorney, a new counsel of record.
Okay, so I'm either going to bring the jury up and we can go forward or not. Let me know whether you want me to bring the jury up, the jury pool up. This is your one opportunity to put on your case. You're the plaintiff. It's a civil case. You didn't have to bring this case. It's not as if you are a defendant in a criminal case. So we're either going to have a jury trial today or we're not. It's up to you. And I'm going to ask Dr. Blatter as well, because you're two separate plaintiffs, although you have...
Okay, no, we most certainly are not having a jury trial today. But just know what you're doing also. You're setting things in motion here, which is not ending here.
Okay.
And there's ramifications for everyone.
All right, defense?
Well, Your Honor, in light of the plaintiff's remarks that they had no intention of putting on the case, I believe that means that they will not sustain their burden of proof. So on that score, I would ask the court to enter judgment in the defendant's favor one and all.
All right, I'm going to enter judgment in favor of the defendants in this case, and this case is dismissed. All right, would you call down to the jury commissioner and let them know we don't need the jurors? Thank you.
Your Honor, one other thing. Steve brought on behalf of Patrick Smith. I would ask that the court make it clear that there's no just reason for delay and that a final judgment entered. The reason I say that is Your Honor granted summary judgment to certain defendants during the course of the case, and there's no final judgment for them. But more importantly, there is an interlocutory appeal pending before the Maryland Appellate Court restricted solely to your dismissal of the claims for injunctive relief relating to the alleged zoning violations. And what I would ask the court to do is enter final judgment as to all claims in the circuit court, so that if there's going to be an appeal, that can be joined with the interlocutory appeal currently pending, and we can move toward getting beyond this case. In other words, I don't want to wait for that interlocutory appeal to be ruled on, have it come back, and then we enter a final judgment.
I'm not sure what the effect of a final judgment in this case is with respect to the interlocutory appeal. I would think it would be a final judgment on everything. I'm not going to make a decision on that. That's really for the Appellate Court of Maryland to look at. But what I will do is, again, this is a final judgment, which means for those defendants that were dismissed on summary judgment, the clock starts ticking now for the appeals on their claims as well. So I think that's how that will operate. But this is a final judgment. I will enter it as a final judgment. I will issue an order, and there's going to be a docket entry as well. There is no good cause for delay. This case has gone on since 2021. The motion to withdraw was by consent. The continuance was in no way premised on a granting of the motion to withdraw. So the plaintiffs have really put this together on their own. I'm not sure why you made certain decisions or what you were thinking when you made those decisions, but you are where you are. We have all the witnesses here. We have limited use of this courthouse when we're coming from other counties. This case has been scheduled for quite a long time. It's been postponed several times. The continuance was denied twice by the administrative judges of this court, denying it again today. And again, final judgment is entered in favor of the defendants.
Thank you.
Thank you.
Thank you.